Michael Alkaraki, an attorney at Lakey and Hosty in Chicago, where I practice personal injury and medical malpractice for plaintiffs. And I'm the host of today's program of You in the Law, which is a production of the Chicago Bar Association. And on today's show, we're going to explore issues related to intellectual property, issues that are oftentimes encountered by artists and entrepreneurs. And we're lucky to have with us two attorneys who have a variety of experience on sort of both sides of the issues we're going to be talking about today. We have Chris Niro here, who's an attorney and founding partner of Niro Law Group, and Paul Farahvar, who is an attorney and founding partner of the Farahvar Law Group, and they're going to give you a little bit more information about themselves. Chris, go ahead.
Thanks, Mike. I appreciate it. Paul, it's good to see you.
Good to see you.
Glad to be here, and I'm glad to have the opportunity to talk to the people about what intellectual property is and issues that an artist or entrepreneur might face going forward with designing a business, building out a product, bringing things to market. So I appreciate you having me today.
Yeah, thanks. Good to see you guys again. Definitely looking forward to it. I could definitely look at it from an artist standpoint, being a former musician myself, and I could see it from both sides. And obviously we both get the same calls that we get from people asking for legal advice when and if they have rights.
Sure. So why don't we start with just kind of a broad overview. When we talk about intellectual property, what does that mean?
Sure. Intellectual property is what we call a bundle of rights that pertain to creations, inventions, expressions of ideas, not ideas. I want to get that very clear. An idea is not protectable in any regime of copyright, trademark, patent, trade secret, whatever it is. Only the expression thereof. So if you have a device, that might be patentable. If you have a name of your business, like Paul and I both have the similar ending of our law firm names, the law group, that would not qualify for a trademark, but our own names actually do qualify as trademarks. And as musicians, artists, sculptors, that falls generally in the copyright domain.
Okay, so we already are kind of getting into these sort of subsets of what intellectual property may be. I think people have a very general idea of, they hear about trademarks, copyrights, licensing agreements and rights, these sort of things. How would you break down these intellectual property subcategories into the big ones that people hear about from time to time?
Sure, no problem. One of the calls we get pretty often is, from at least recently, is people who say, I've got a great idea for an app to put on your smartphone, your iPhone, whatever it might be. And I want this idea, I want to get a patent on it. And say, okay, well, let's talk about that. Because patent laws, trademark laws, and copyright laws all play a part in someone developing an application. And there are other rights that you have to be sure you are taking care of, like your rights of disclosure, publicity, and other things. It can balloon pretty significantly right off the bat from a relatively innocuous question.
Sure, and let me stop you right there for a moment. You mentioned copyright, trademark, and patent.
Yes.
Can you tell us what each one of those is?
I'll throw it to you.
Well, no, you go ahead. Copyright is basically the expression of an idea. If you have a song, a work of art that's been expressed in one way or form, any shape or form, that's a copyright. A trademark or a trade name or a trade logo is like the common things you think of, like McDonald's or Nike, the golden arches, that's a trademark. And the goal of that is to protect you from people getting confused with other products and to protect what good name you've provided in the marketplace. Patent, I'm not a patent lawyer, so why don't you go ahead and take that.
Sure. A patent is generally directed to a useful article, whether that be a device. This pen, for example, may have had a patent on it previously. Cameras, lights, sunglass lenses, believe it or not. And one of the other things I want to talk about, software. Software falls within two different regimes. It can be patentable, though the courts have been reluctant to uphold patent rights in software recently, and also in copyright, because it is, by definition, a literary work. It's written code that you can submit to the Copyright Office and obtain a copyright registration on. So the way something functions, that is falling within a patent right off the bat.
Okay, so let's start with something, maybe we can get some examples or anecdotes. People are generally familiar with the idea of musician writes, publishes, performs a song, and someone else may be inspired by that, may plagiarize it, which is probably not the proper legal term, or vice versa. The popular song could be the product of someone else's work that didn't really get attention.
Sure.
And I know, as a matter of fact, you've been involved in some litigation. I don't know to what degree you're at liberty to talk about some of this stuff, but I know some of it's been in the press, so why don't you tell us about some of that?
Sure. And your first question was a really good one, and the difference between copying and being inspired by something. I've asked some well-known musical recording artists where the line is between being inspired and where copying begins. And they don't have a very good answer for me, and I don't think there is a very good answer for that. In copyright law, whenever we're talking about musical works being similar to or a copy of somebody else's work, the test that we use is whether it's substantially similar. And that goes into even further delineations of how the artists may have had access to the previous work, whether they knew of the previous work, and then what actual components of that song is shared by the previous works. And that's a very fact-intensive inquiry, and I'll be in front of the Seventh Circuit maybe in the coming future to discuss that very topic.
Good luck.
Thank you.
So let's presume that the folks who are watching this are on the side of things where maybe they have a piece of art, whether it be visual, music, etc., and they feel that someone else has used it and generated some fame or profit or some other thing from it. What should someone like that do if they feel that their work's been used by someone else who hasn't credited them or gotten permission?
Sure.
I mean, well, first thing, they need to call a lawyer. Don't take actions into your own hands, because that can make it even more sticky. But essentially, if you have the thing with the music, I want to add to what Chris was saying is, if you boil down all rock music or anything, there are going to be a lot of substantial similarities. The question is, it's more than that. I mean, if it's a copy or a blatant lift, you'll see that a lot in sampling right now, where people are sampling songs, or you listen to it and you're like, wait, I've heard that before. That's where you can kind of determine, hey, I should talk to a lawyer. But if someone has like the same chord progressions as you, a lot of songs have that. But if it's something, and we've seen it in the news with a lot of popular artists right now who are sampling or literally copying classic works of art, and that's where you can kind of tell that you might have a case. But when you talk to a lawyer, they'll be able to tell you what your rights are, whether it's a song, whether it's a work of art, or anything, quite frankly. But the first thing to do, I guess, to answer your question is get a lawyer involved.
And I would agree with that. Even before you go and talk to the alleged infringer,
Right.
Don't send letters. Don't say, hey, you stole my work. Talk to a lawyer first.
Why not do that?
Well, right off the bat, you might be saying something that you are not accurate on. And if you go and claim that you are being infringed by somebody, they may have grounds to file a declaratory judgment against you, saying there is no infringement, and then you're playing on their home turf.
Sure.
And that happened with Robin Thicke.
Right.
Robin Thicke and Pharrell Williams and the estate of Marvin Gaye. Marvin Gaye's children said, look, we think you're infringing our song, and Robin Thicke turned around and sued them. And, well, we know how that turned out at this point, but that's always a
Could
possibility.
have gone the other way. Right. And that's the other thing, too. You're also giving them an advantage where they might have contacted legal representation, and they're going to take the steps necessary to protect themselves. Or if they don't have attorneys, maybe hide some significant evidence of how they had access to it, which I've seen as well. So
Yeah.
you want to get an attorney, and most attorneys you contact will give a free consultation early on. I know I do it. I think Chris does it as
do.
well. So, and we'll be able to get information from you and make a determination as to whether you have a case or you don't.
Sure. Taking a step back from the more sort of heavy-duty intellectual property stuff, just to kind of basic business formation, how to get your business started. Have either of you had occasion to discuss that with someone who's either thinking, look, I have a business idea, or I have some content that I'm kind of creating, whether it's on the internet or music or something else, another piece of art. Have you given advice to folks in that regard? People who are just kind of out there doing their thing, but think it might be time to sort of formally incorporate?
Sure, and yeah, I know I have it, but you have
Yeah.
also. That's usually the example I gave you. Is someone calls me saying, "Hey, I want to develop an app for your iPhone." More often than not, in my experience, people who have called me are not the actual software programmers. They're able to create the code to make the app function. So what we generally advise, as I would advise, is other than first calling a lawyer, which if you're watching this, you probably would call a lawyer first. But one thing right off the bat you want to do is have a non-disclosure agreement with the software developer that you are going to be talking with. If you're going to have a company, a lawyer can assist you in forming a limited liability company. It's very easy to do. You could do it yourself, but odds are you might miss something. And if you miss something, it's on you. Whereas if you have an attorney to guide you through it, you'll probably do the first thing right.
Sure.
Yeah, I mean, that's the non-disclosure agreement is such a key aspect, because if you talk to somebody, especially with software, they can go ahead and just do it without you. I mean, you have a great idea. Once it's been expressed to some third party, you really have no protection.
Right. And especially, let me add on to that, because the copyright in whatever you design is vested with the artist unless you sign an agreement transferring those rights. So even if I pay you to design a piece of software code, if I don't get a written assignment of that code, you own the rights to it.
Sure.
And this work made for hire, you have to be very specific in your agreement.
Language, right?
The language of your agreement with them to make sure that you do get all right, title, and interest. Because as I've told several clients, once the genie's out of the bottle, it's very difficult to put it back in with copyrights.
Okay, there's a concept out there that I think is generally, people have an understanding or heard the phrase or term having an intellectual property plan or an IP plan as part of their business to kind of protect and make sure they own everything they do produce. First of all, is this something that's, I'm sure it's pretty common, and what are the basic elements of an IP plan for a small company, or maybe it's similar even for a large company? I'm not sure.
I mean, it really depends on what you have. If you have a software company, the first thing you got to do is create a business, whether you're going to be a corporation and whatnot. But depending on the size and what you're doing, you definitely want to get agreements from your employees and independent contractors right off the bat.
And this is kind of that non-disclosure type.
Well, a non-disclosure, right, or a non-compete even I would do for employees, because they can go ahead and start something that competes, which we've seen in many instances with applications right now. I think there's dating apps that have been copied from former employees or former staff. So those are the first steps, and then obviously the registration. If you have a copyright, you want to register right away.
How do you do that?
You go to copyright.gov, and they have step-by-step process. They have lawyers that can help you, but realistically, if it's a complicated item, you should get a lawyer involved early on to make sure you do it right. Again, Chris already said it's on you if you do it wrong, and it's a process that you need to do. When you express whatever it is that you have in a copyright, whether it's a song, artwork, or whatever, once it's out in the open, it's copyrighted. But to protect that right against infringers, you need to register, because without that protection, you really have difficulty collecting attorney's fees, which is, well, actually, you can't collect attorney's fees, right? So
we will get to that. We're going to have to take a short break, and we'll come back for part 2, which we'll explore even more reasons why you should call an attorney